Good day and welcome to the Undisciplined podcast. I'm your host, Dr. Nico Buitendach, and today I have the distinct pleasure of speaking to Professor Visa Kurki from the University of Helsinki, where he is an associate professor of jurisprudence. Visa is an expert on the topic of legal personhood and how it relates to animals, to nature, to AI, and that's what we will be talking about today. He has published a monograph, A Theory of Legal Personhood, with Oxford University Press a few years ago, and more recently a book called Legal Personhood with Cambridge University Press. We talk about his thoughts and work on legal personhood, which I believe is an exciting new frontier in legal theory and deserves our attention. This is also the first time that the video version of the podcast will feature real video, not just an audiogram, so I hope you like it. Don't forget to like and subscribe. But anyway, here is my conversation with Visa. Visa, welcome to the podcast. It's a great pleasure to have you here. I think before we get into your really interesting work, I usually begin with asking a bit of your academic or intellectual background and history, and maybe how you got interested in legal theory and specifically the topic of legal personhood.
Mm-hmm. Sure. So yeah, thanks for the invitation. It's nice to be here on this podcast. So I'm Finnish from Finland, originally from the town of Turku, though I now live in Helsinki. So, yeah, I don't know, like, where should I start exactly? But basically, already I'd say in high school, I got very interested in things like philosophy, even to some extent theology, these kinds of questions. And that's when I also already developed an interest in animal rights and animal ethics and those kinds of issues. I think, as for many other people, reading Peter Singer's Animal Liberation was sort of a very central influence. Then I had to do something that almost all Finnish men have to do, which is a military or non-military service. And I did a non-military service, meaning I had to work in some sort of a non-profit context for a year. And I worked at the student union of the University of Turku. And there I got to sort of see from the inside a little bit of how different academic fields work. And that's also when my girlfriend back then got sort of interested in applying to law school, and I sort of could peruse her materials and so on. And that's when I thought that maybe I should apply to study law instead of philosophy, for instance, partly because I realized that there was this sort of philosophical side to law that is maybe not apparent in sort of the public perception of what law is and what lawyers do and so on. And well, I did actually then study the sort of faculty of politics for a year, but I then switched to law after that. It's an undergraduate degree in Finland. And when studying for my bachelor's degree, so that's a 3-year degree, I had to write a bachelor's thesis, and that's when I got interested in animal law specifically. And I sort of hadn't realized at first that this was an issue that you could do as a law student or a legal scholar. But there was one person at my university, or back then I think she was still a PhD candidate, but Birgitta Olberg, who gave one lecture on sort of animal protection law. That's how I got interested in the animal stuff. And then I wrote my bachelor's thesis on like animal protection law. It was not very philosophical. It was legal doctrine about Finnish animal protection law. But that's when I first encountered this claim that even though we protect animals, they currently do not hold legal rights because they're not legal persons. So they would first need to be declared legal persons in order for them to be able to hold rights. And that's how I got interested in this topic. Then after that, I did my master's in Helsinki, and I specialized in legal theory. So I wrote my master's thesis in the sort of legal theory seminar. And the basic research question of the master's thesis was, could animals be legal persons or legal subjects, as I think you would also say in South Africa? That's like a civil law way of putting the question. Could they be legal subjects? And there I still sort of, in a way, took for granted the idea that animals currently do not hold rights. But then I got sort of increasingly sort of dissatisfied with how we understand legal personhood. And I decided to do a PhD on the topic of legal personhood specifically. So not just about animals or any other particular case study, but rather looking at the actual concept or property of being a legal person. And by the way, I should say that many people were not very encouraging about this. They felt that it was too broad and too sort of vague and well, anyway, but this was the topic that interested me. And I ended up at Cambridge University, ultimately in the UK, doing the PhD with Professor Matthew Kramer, who was very sort of interested in the idea. Yeah, well, that's, I guess, the background to how I got interested in legal personhood specifically. Yeah.
Yeah. So that's actually something that you've been interested in for a long time. It started that interest started fairly early in your studies. And you've pulled it.
Yeah,
through.
It started quite early, and it's a bit hard to explain why I found it so fascinating. And as I maybe already sort of hinted at, so it was not a big topic. So I mean, today it's sort of everyone's talking about legal personhood. Well, not literally everyone, of course, but I mean, so there's all these developments about rivers having rights of personhood and AI personhood and so on. But 10, 11 years ago, it was a very different landscape. And it was also like when I was writing my PhD, so, I mean, it was very hard to find the literature. It was not sort of an established debate, whereas I think it's now gradually becoming established. But it was sort of a dormant debate. People have been debating this stuff for 100 years ago, but not sort of in the contemporary era.
Right. So I think before we can really talk about anything more or more substantively, we need to start with the basics, with definitions. So we're talking about legal personhood or subjectivity. So for someone who does not have a legal background, what do we mean by legal personhood or personality, and how has that traditionally been understood?
Right. So I think especially in the English language, first of all, already the person is a bit tricky, because the word person can mean, for instance, being a human being. So a human being is a person. And if you read moral philosophy, personhood has a specific meaning there. And in psychology, there's talk of personality types and so on. So it's very easy to get sort of maybe sidetracked when talking about this issue. But I think in law, the sort of most typical way of talking about legal personhood or legal personality is in terms of who or what is a right holder or a duty bearer, who or what has legal rights. So those beings are legal persons. And I think what I in my work call the orthodox view of legal personhood. It's basically the idea that there is this very simple black and white distinction between persons and things, or subjects and objects would be the other sort of pair of labels. So a person is someone or something in the legal sense, a person. So a legal person is someone or something who has at least one legal right or duty, or has the so-called capacity to hold legal rights. Whereas everything else would be a thing. So you have to be one or the other. You have to be a person or a thing. So that's what I call the orthodox view, this sort of black and white picture between persons and things. And in my work, I then propose this alternative definition of legal personhood, an alternative theory of legal personhood. And that theory says roughly that it's a cluster concept. So it means that being a legal person doesn't merely mean that you hold at least one right or one duty, but rather that paradigmatic legal persons, like human beings, but also corporations, hold a good number of different kinds of rights and often duties. And those I call incidents of legal personhood. So in sort of property law and the theory of property law, there's long been this theory that ownership is not just a single legal right over a thing, such as whatever. I've got a cup of water here, so I mean that I own this cup doesn't just mean that I have one right over it, but rather there are various sorts of different rights, such as that I can sell it, and if I can make a profit out of it, I get the income, and I can destroy it, and all kinds of rights. And basically, I apply a similar kind of analysis to legal personhood. Being a person also means having a bunch of different kinds of rights and duties. And then there are these paradigmatic cases, like a born human being would be a paradigmatic case. And even though babies are not yet what I call active legal persons, so they can't yet make decisions about their own lives, they still have actually a rather large number of rights that unborn babies don't yet have. And then as they increase in maturity, they will also become what I call active legal persons. But then an active legal person would mean that they can make decisions about their own lives, but they are also responsible in different legal settings. On the other hand, there are some cases of sort of less than paradigmatic legal persons, though for the sort of most of the 20th and 21st century, it's been a relatively clear line that you are either a natural person, meaning a human being, or artificial person, meaning some kind of a corporation. The corporation here can also mean, for instance, a non-profit. It can mean a university, for instance. But historically, I think my view better can account for cases like, for instance, the gradual development of women's rights. So it's a bit implausible, or as a background, I should say that many scholars think that women have not always been legal persons in all jurisdictions. So one famous example is the English common law doctrine of coverture, which, according to which women were sort of part of their husbands or a father's legal personhood. And my claim would be that it's still plausible that they already held some limited legal rights, but their development to sort of full legal personhood has been gradual. They have gradually received more legal rights and duties. Mm-hmm. And now women are definitely full paradigmatic legal persons.
So, to build on that, you say, okay, we've got the kind of the traditional or orthodox categories of legal persons,
simply put, human beings, and then legal persons or artificial persons like corporations or so on. Now, of course, and this is also why this question of legal personality is becoming interesting, I assume, is because we are increasingly hearing claims that rights should be extended to let's say non-traditional entities, such as animals, such as natural phenomena like rivers or ecosystems and so on. So I think very few or only kind of strange people would argue against the protection of animals or nature. But the question, I think a more reasonable question would be, why extend rights, this very like social legal construction? Why extend? What are the arguments for extending that to animals or to natural phenomena?
Right. So this partly sort of depends again on what we mean by both rights and legal personhood, and I maybe didn't mention or discuss the question of rights that much, but sort of on the sort of orthodox view. So there's this very, very close connection between rights and personhood. So basically, you cannot hold rights without first being.
No, I'm jumping a little bit from the question of personality to rights, but
right,
yeah,
and that sort of traditionally that's what you do. So you can't really talk about rights without personhood. Though I think it leads to these sort of counterintuitive ways of talking in some cases. So, for instance, the sort of traditional way of talking about animal rights would be that right now, even though we protect animals, that's not rights; it's only protection. But then if we were to give animals personhood without actually changing their legal status otherwise at all, then suddenly they would have rights. And to me, that's counterintuitive. So anyway, on the sort of orthodox view, so if animals or nature or AI systems have at least one legal right, then they are persons. So this is sort of very closely connected. But I have a bit of a different view. And it's roughly the following. I say that animals, I think they're the clearest case here. Animals already have legal rights in any jurisdiction that protects them through the imposition of duties upon humans to treat animals in a certain way. And this follows from something called the interest theory of rights. So a way of analyzing rights according to which if I have a duty that benefits someone's interest in this sort of specific way that I wanted to go into here, then that entity who is protected has rights. And therefore, we already protect animals' interests in a way that I would say, according to the interest theory, already results in animal rights. So in itself, the sort of extension of rights is or rather like the question of should we give rights to animals, for instance. Again, I think nature might be a bit of a different case, but the question of animal rights, at least, is sort of I think the question is somewhat problematically put because we have already given rights to animals, you know. But then if we get to this special bundle of rights, which is sort of legal personhood. So there are sort of different reasons why we might want to give these rights to, for instance, well, animals or nature. So let's talk about nature for a change. But by the way, I'm sort of skeptical. I have some sort of philosophical issues with talking of rights of nature. But if we just talk about sort of the sort of practical effects of these kinds of arrangements. So there is this distinction that I think is quite useful, that there are two kinds of sort of rights of nature arrangements. One relies more strongly on legal personhood specifically. So, for instance, in New Zealand, a river, I'm never sure how it should be pronounced, but Wanganui, the Wanganui River has been endowed with legal personhood. And this has sort of very specific legal implications. So, for instance, supposedly the river, though I would maybe rather put it that it's the sort of governing body of the river where the Crown and the Maori tribes are represented. So they can sort of protect the river using means that are normally only available to legal persons. So, for instance, they can sue other bodies if they, let's say, pollute the river. They can own property and buy services to take care of the river and so on. So I think the benefits there are a bit similar to corporations more generally, like the benefits of incorporation more generally. But then there's a very different branch of rights of nature, which is more about giving constitutional rights to nature more broadly. This has been more popular in some Latin American countries. And to me, it's not obvious that is really about legal personhood. It's about making nature a subject of constitutional rights. But constitutional rights do not obviously mean legal personhood in my meaning of the term.
I heard you say in another lecture I saw you give on YouTube, you mentioned, the distinction between natural law theories and positivist theories. So I want to, and that got me thinking a little bit, and I want to touch on that. Do you think, and I think of this in the context also of the climate crisis and so on, do you think that the arguments for personhood and then by extension giving rights to animals or to nature, while you do have your reservations about the rights of nature, do you think that this should rely on a moral or ethical argument for, especially in the case of animals, about, the kind of similarities between humans and animals, for example, sentience or the ability of animals to suffer, these kind of extra legal arguments? Or do you think, and I think this is perhaps where my own sympathy is lying, from a very positivistic, legally internal point of view, for arguing that there's a useful legal function to doing this, that perhaps it makes the law more effective or more coherent in fulfilling its social function, that it is more beneficial for humans if we instrumentalize the law in this way. Where do you think you would lie, or do you not even agree with this distinction I'm making in the first place, or you think is it relevant or not?
Yeah, it's relevant. I guess for the first issue I'm wondering is if this is sort of strictly a question of positivism versus natural law. Of course, those concepts are also so contested that I can see why you would sort of think that one would fall more straightly within the positivist camp and the other the natural law camp. But maybe I think in either case, and I'd say I'm mostly a legal positivist. So legal positivism here would mean, of course, that the sort of validity of law is not directly dependent on sort of its moral content, or whether it's morally sort of morally correct, morally right, morally acceptable. Well, I think it's maybe more useful to think of this in terms of what kind of justifications there can be for the legal personhood of some entity. And you can think of this in terms of intrinsic and instrumental justifications. So an intrinsic justification would be that some entity should be a legal person for that entity's sake, so maybe by giving that entity legal personhood, we express respect for that entity or somehow express recognition of that entity's moral worth, ultimate moral value or something like that. And that's I think lies in the background of our modern human rights doctrine, for instance, where it would be unthinkable to deny legal personhood to some entity, to some human being, I mean. But then instrumental justifications, I mean, so I think like corporations are maybe more straightforwardly, the fact that we have corporations. And by the way, I guess I should mention that corporate personhood doesn't just mean that corporations have constitutional rights, or I mean, in the United States, corporations have constitutional rights, but not in most other countries. I think in most other countries, corporate personhood just means that they have the same kinds of sort of statutory rights as human beings do. So I think corporate personhood is probably easier to justify using the sort of instrumentalistic reasoning. So basically, we will achieve some kind of good effects for the society by giving corporations legal personhood. It will allow us to accumulate resources for shared projects or something like that. Another question is, what about these new groups of entities like animals and nature and so on? And I think with nature, for instance, I can definitely see the instrumentalist justification there. And I think that's been one of the sort of original motivations behind the rights of nature movement, which is that the sort of traditional environmental law is not working. It's not succeeding in the protection of various environmental objects, rivers and so on. And of course, the original famous question was, can trees have, or should trees have standing? As regards animals, so I think, of course, that animals should have strong fundamental rights and therefore probably some form of legal personhood, because they are sentient beings, at least those animals that are sentient beings, and therefore have a sort of a strong ultimate moral value. But that doesn't mean that there would not be also other good reasons for giving animals either stronger rights or legal personhood or both. For instance, the current exploitation of animals doesn't only hurt animals, it also hurts us in various ways. It contributes to environmental degradation and climate change and so on. So I think those two issues can sort of converge. They can be both instrumental and intrinsic reasons for the personhood of animals, for instance. And I think with AI systems, then, assuming that we won't have sort of sentient or for some other reason morally sort of ultimately valuable AI systems anytime soon, there's the question of, could there be other reasons for giving AI systems legal personhood? And there, I think like the instrumental reasons might be more plausible. Though I think there might also be risks there, but maybe there might be some reasons of economic effectiveness, for instance, why some AI systems should maybe have some kind of legal personhood so that we could treat them as separate subjects of responsibility, for instance.
Do you mind perhaps zooming in on that a little bit? Maybe the good reasons for granting AI personhood, and also you mentioned that there are risks attached to that. Do you mind elaborating a little bit on those pros and cons?
Yeah, sure. I mean, this is not something that I've maybe specialized on recently, at least. But I have a research project here in Helsinki right now where we have one postdoc looking at sort of the treatment of AIs as legal agents. But in any case, so I think many of the sort of benefits can be relatively sort of mundane in a way. So it's not necessarily the kind of stuff you see in sort of sci-fi, books and movies. It's not that, we have these very human-like robots that are deserving of being recognized by the law in their own right and so on. It can just be that
it would be closer to a corporation. In comparison, right?
Yeah, probably. So, I mean, it could even be that a corporation wants to set up a separate sort of legal entity run by an AI system that would then start doing some kind of a trade in the stock market or something like that. And the corporation could benefit from it because they would be sort of isolated from the risks because of if there were sort of two separate legal persons there with limited liability in between. And of course, that also brings us to the risks. So this would, in this case, this would be one way of the banks sort of shielding themselves from responsibility that maybe, I guess, many would think that the bank should take responsibility for. But that would be just one example. But I mean, there are very different discussions going on. So I mean, in my book from 2019, I distinguish between three different contexts. So one is what I call the ultimate value context. So this would mean the context where we talk about AI systems as being sort of valuable for their own sake. And that's what I call the responsibility context, where we talk about responsibility in this sort of broader sense of, we have self-driving cars. So who should bear the risk that the car drives over someone or the other way, acts in breach of traffic rules or whatever. And then the third is the commercial context, where we would have AIs acting as commercial agents. And I'm sure there are other contexts as well that I have not thought about. I think there was recently a book about non-humans as creators in the sense of copyright law. So there would be the issue of both AI systems and animals. So I guess that could maybe be another context, unless you want to classify it under the commercial context.
Yeah. Okay, so to maybe put it together, everything that we've spoken about so far, about animals, rights of nature, AI, so on, and you said the orthodox view of personhood that we've had for a century or so. You propose in your work what you call a bundle theory of personhood. Now you've given a lot of clues on that already. But do you mind just summarizing what you mean or what you propose with the bundle theory of personhood? How we can understand these different types of or categories of entities, how we can put them together under one kind of unified conception of legal personality.
Right. Yeah, maybe I should be more explicit about it. So according to the bundle theory, so what makes something a legal person is, well, first of all, it has to be an entity that can, for instance, hold what I call claim rights. So it can sort of benefit from others' duties in a way that means that it can hold rights and so on. So that's why I think I'm skeptical of nature being a right holder, sort of in the ultimate sense, as distinct from being. So just to be clear about my skepticism about rights of nature. So I think we can definitely have these kinds of what I call legal personhood arrangements, that where we set up a legal person and call it the River X, for instance. But then the question is this any different from corporate personhood? That's the question I've been wondering about. So to me, it's not obvious that it is any different. So it seems that we set up a corporation to protect some kind of a river, for instance. Corporation in the broader sense, again, sort of like a foundation. But anyway, so that's the question of who or what can be endowed with the incidents of legal personhood. But what are the incidents then? So I distinguish between passive and active incidents. So passive incidents are such that they can also be given to, say, human infants. So they don't require the kind of sophisticated agency that we traditionally have presupposed of, for instance, the capacity to decide about your own affairs. And I think it's quite useful to think of this in terms of, if we compare a newborn baby with a baby that has not yet been born. So how are their legal statuses different? Well, first of all, I would argue that both already hold legal rights, because if we have a late stage fetus, that fetus already has some rights against abortion. So this doesn't necessarily mean like a strong constitutional right to life, but we do indeed restrict sort of the mother's right to abortion the further the pregnancy gets. So I would argue that there are already some limited rights, but then the question is, what about the legal personhood related rights? So there are a bunch of these incidents. So one is, for instance, what I call legal standing. A legal standing here means that you can sort of appear, for instance, in a court in your own name, that you are treated as a potential party to a lawsuit. And babies can be potential parties to lawsuits, whereas normally, again, this is somewhat jurisdiction dependent. Fetuses mostly cannot, with some limited exceptions. Then babies can be legally harmed, meaning that if I harm a baby, I normally have to pay compensation, for instance, to the baby. Whereas the case of the infant, this would only be there is something, I'm not sure how you pronounce this Latin word in English, but nascituros is how we would pronounce it. Yeah. So basically, there's a rule that infants are retroactively treated as legal persons for some purposes if they're later born alive. So, for instance, if you harm an infant so that the infant suffers some kind of permanent harm, but is regardless later born alive, then you do have to pay compensation. So liability or capability to suffer legal harm is another example. Then there's something that I call fundamental protection. So this would basically just mean that you are strongly protected. Your body, life, and those kinds of things are strongly protected by the law. And again, we protect unborn babies to some extent, but not to the robust extent that we protect babies. Then there is something that I call victim status in criminal law. And this can sort of be cashed out in somewhat different ways, but generally crimes against legal persons are treated differently than crimes that are, for instance, crimes against animals, for instance, because crimes against animals are treated as crimes against the public order usually. So the animal is not treated as a victim in the suit. But this is somewhat jurisdiction dependent again. Legal persons can own property. They have property rights. And they can be subjects or parties to all kinds of so-called special rights, so meaning, for instance, contracts. So there can be, at least for instance, about Finnish law, I can give a gift to my baby, and I can even, in some cases, enter some kinds of contracts with my baby, or someone else can, though the baby would then in a separate representative, of course. Whereas I cannot do that with my cat. So the cat simply cannot own property. I think in the common law, you can sometimes circumvent this using trusts, but in civil law, we normally cannot do that. And the same goes for contracts with cats. I cannot really enter a contract with my cat, where I would sort of agree to perform some services and that the cat would, I don't know, agree to something else. That would not be legally valid. So it's these kinds of rights that I call incidents of legal personhood. I hope that roughly made it clear.
Yeah. I can see the bundle of rights and it being incidents of personhood. But speaking of when we speak of personhood, right, we're talking about something that's really fundamental to any legal order. I mean, it's like a basic building block. So, and this is perhaps slightly broad, but I'm wondering about if we change, and okay, I realize a lot of your argument is saying that we're doing a lot of this stuff already anyway. But I'm wondering if we start thinking of personality differently, do you think it would have a big knock-on effect or disruptive effect to the broader legal system if you change something that basic?
Right. So maybe in the background there's this assumption that we've had the existing categories for a very long time, and now we're suddenly starting to change them. But I mean, these categories have been in flux all the time. I mean, you have these. There are these some cases where, by the way, I'm often not fully convinced that, I think these examples can sometimes be misleading. But I mean, historically, there are some cases where ships have been treated as supposedly legal persons. Though I think we should be a bit reserved about that. And again, like if we consider even the legal personhood of human beings, so there have been enslaved people whose legal personhood has mostly been denied, and as mentioned, women's legal personhood has mostly been denied in some jurisdictions during some periods, and so on. So it's not clear to me that these would be sort of the boundaries of these categories would have been unchanging for centuries or millennia. But of course, especially if there were very wide-ranging changes. So if, for instance, let's say all sentient animals would suddenly receive a rather strong form of legal personhood, then that would definitely mean a very big change in how our societies and legal systems work. If you actually took it very seriously that every animal in the forest would have roughly the same kinds of rights as we have. Maybe not, for instance, ownership rights necessarily, or those kinds of rights, maybe like rights to bodily integrity, maybe, and legal standing, and those kinds of rights. So it's more like through those substantive effects that I think this could be very upsetting. But if you meant that whether simply changing the categories themselves in itself would be sort of very upsetting for our legal thinking, I'm not as convinced about that necessarily.
Yeah. Well, I think you give a very coherent legal theoretical account or framework for this. I suppose what I'm thinking about more is the kind of practical, simple questions of like procedure or administrative law or something like that. If those would, if unforeseen problems would pop up there.
Yeah, I mean that's probably true. And again, like, I think it partly depends on the scale of the change we're thinking about. I mean, right now we got some cases of rights of nature, and those jurisdictions are now dealing with the issues that those cases cause. In the U.S., there are some states where so-called pet trusts have been sort of introduced, where you can sort of in your last will and testament leave some money for your pet, your companion animal. So that would be another case where some limited type of legal personhood or some incidental legal personhood have been extended to some animals, and these do of course pose difficult kinds of problems about questions like how do we establish the best interests or in the will of the animal or the river and so on. These kinds of questions, which are quite difficult. So that's maybe one issue. And then I guess a different kind of issue is then if this would become a very pervasive feature of laws. If, for instance, we have the case that all animals have strong form of legal personhood, or all sentient animals, then that would really mean that we would need to think differently in terms of administrative procedure and everything if we suddenly have billions of new legal persons. But going back to the sort of just the more conceptual question, so I think this is something that I've been very interested in recently, and we have this research project here in Helsinki where we're looking at the question of agency in law. And one aspect that I've been interested in is sort of, there has been this, and this is something that I sort of have neglected, I think, in my earlier work to some extent. So there is a sort of traditional picture of what it means to be sort of an active legal person, of someone who can make decisions in law and so on. There's this idea that you are sort of a rational, atomistic individual without mental disabilities and so on. But this has actually, if you look at contemporary human rights law, this has changed a lot. So, for instance, people with disabilities are increasingly being treated as sort of active agents in the law. And more recently, there have also been proposals that even non-human animals could have some kind of agency. So in that case, if animals had a strong form of legal personhood, it would no longer merely be a question of establishing their best interests, but also a question of establishing what they want, or at least somehow trying to listen to them. And that would, of course, pose further problems for administrative procedure, for instance, or court cases and so on.
Well, just listening to this, my first instinct, as we mentioned, my Lumanian background would be that perhaps it's going all the way in the other direction of saying, well, even human agency is just something that's attributed by an observer, by the legal system. And that conceptually there would be no problem attributing it whether to a human or to a cat. But yes, it would be the job of the legal system or of humans to make meaning of that, of the action.
Right.
Yeah.
Yeah, I mean, yeah, it's quite interesting. I've been reading a little bit of, not that much Luhmann recently, but some Günther Teubner, who is sort of a Luhmannian a little bit, and also some Habermas, and I could sort of see the argument, but at the same time, so I mean, there's something. This is something that I've been working on very recently, and I'm very sort of open to different kinds of arguments right now. But I think from a sort of traditional legal theory perspective, there are these issues like, for instance, the traditional picture of a contract, of just a legal contract, is that I intend to be bound by a contract. I intend to legally create a certain set of rights and duties between myself and someone else. And it's quite difficult to sort of transpose this idea to non-humans who don't necessarily have these concepts of like being bound by, or the concept of law, or those kinds of questions. And to some extent, you can probably subvert them. There is some interesting work being done on issues like, well, if animals cannot consent, maybe they can assent, for instance. So assent would be sort of whether you sort of go along with something as opposed to sort of physically stand in opposition to something. So there have been, so one suggestion would be that we need to think of these conceptual categories a bit differently. But
yeah, that's very interesting. Well, Visa, thank you. So just finally, I think you've kind of bracketed the rights of nature topic. You have some skepticism towards that. So let's put that to the side, but and focus specifically on animal rights and animal personhood. So my final question to you is, what do you think the short to medium term future is for animal rights and animal personhood? Where do you see it going, and what do you think will be the challenges that we face at the moment?
Right. I think with animal personhood specifically, I think it seems to be getting increasingly heterogeneous. So I recently published an article called "The Bird's Eye View of Animals in the Law," and there I basically argue that it's maybe even a bit misleading to talk of animals in general, because it seems that the sort of legal status of animals is sort of there's several different legal statuses that animals have depending on whether they are exploited by us on factory farms, or whether we treat them as our companion animals, or whether they are wild animals that we want to protect. So, for instance, for companion animals, it seems that many countries, or at least some countries, are increasingly treating them at least as sort of non-things, or at least, though I would maybe argue that they're sort of new special kinds of things, what I call irreplaceable things. So they have sort of special value for their owners. So I think, and I mean, if you just think of this very recent debate going on in the US about people eating cats and dogs. So, I mean, if the debate was about they're eating, pigs and chickens, no one would have cared, because it's so obvious that, people eat pigs and chickens. Well, I mean, I'm not saying they should, but we had this sort of interesting relationship with animals where some we treat as sort of companions and others as almost pure objects. And then finally, like I think with some protected wild animals, like in the EU, it would be examples like wolves. So they're protected to the extent that I would even classify them as property at all. And I'm not sure whether I would classify them as legal persons, except in maybe some limited sense. So maybe they might have some incidents of legal personhood, because their actually lives and bodies are quite strongly protected already. But anyway, so there seems to be this sort of these multifarious developments going on at the same time, and it's maybe hard to provide one consistent picture of where everything is going. One thing that maybe makes me a little bit optimistic still, and has maybe for a while, is the sort of prospect of artificial meat. So, well, not just meat, but also, for instance, artificial eggs and so on. I think even here in Finland, they have a company that's producing artificial egg white. So it's not just a substitute, but it is the exact same product, but they're producing it in a laboratory. So I think those might sort of reduce the sort of economic interests surrounding animal exploitation. And if you want to be sort of a Marxist about it, you can then argue that if the underlying sort of material issues change, that might also lead to sort of a change in perceptions about how we view animals as whether we view them as resources or as also sentient rights holders who matter in their own right.
Yeah. Oh, that's interesting. Well, thank you, Visa. I think I've taken up a lot of your time already. This is
Thank you. I hope I wasn't too complicated.
No, this is it's truly fascinating, and I think really important, and you know, I think this is something that will be discussed still for many years, and it's only going to grow in importance. And I think you're a leading voice on this. So thank you very much for sharing your time and your thinking on this topic.
Thanks so much. It was my pleasure.